The Fourth Amendment to the Constitution says that persons should be free from unreasonable searches and seizures. So, when you're thinking about the Fourth Amendment, based on what I just said, there are three questions that should immediately pop to mind. One, what is a search? Two, what is a seizure? And three, what constitutes unreasonable? That's our Fourth Amendment, and those are the questions that are inherent in any interpretation of the Fourth Amendment. The Fourth Amendment is vitally important to our democratic tradition because it protects the central pillar of our democracy, and that is liberty. We are a free and open society. We lionize the notion of liberty in America. And the Fourth Amendment is the amendment to the Constitution that protects that freedom.
In essence, the Fourth Amendment prohibits the government from conducting unreasonable searches and seizures, especially without a warrant. This grew directly out of the experience of the American colonists, who were subject to all sorts of searches and seizures of their private goods, primarily by British customs officials who were looking for contraband or were looking for goods that had been smuggled in without payment of the appropriate duty or tax. These officials were armed with something called writs of assistance, which commanded everybody nearby to help them, and as you might guess, they were not very popular with the people who were being searched. Writs of assistance, which the British customs officials used, were sometimes more generically described as general warrants. So they were a piece of paper. They came from the government, not always from a judge, but somebody in the government. And they would simply say, this person is empowered to search for whatever he wants to search for, wherever he wants to search for. In other words, very general. And when you give some government official that much discretion, that much leeway, well, guess what? If you're a hammer, the whole world looks like a nail, right? Well, to them, the whole world looked like some place to be searched. And so these people would just start snooping around on a whim, wherever they wished, and that was what the colonists found the most objectionable. They insisted that if the government is going to issue a warrant, it should be for a specific item or items, specifically described, in a specific place, with specific limitations as to the time that this sort of thing can happen. And the whole idea here was that, yes, the government does have the power to search in appropriate circumstances when there's probable cause to believe that a crime's been committed or might be committed, but it doesn't have, or it shouldn't have, the power simply to snoop around at whim.
Probable cause, which is a standard of belief. It's what do you know about this person that makes it appropriate for you to deprive them of their liberty, typically because you have information that leads you to believe that this person committed a crime. So probable cause is a relatively uninformative two-word phrase, but police officers have to educate themselves about what the courts in their jurisdiction say might lead to probable cause. So there are a lot of circumstances that police officers learn they can take into account. For example, the kind of area in which they see certain behavior. If they know that this is an area where a lot of drug trafficking takes place, they can take that into account in deciding whether some equivocal kind of behavior is sufficiently correlated with drug dealing so that it rises to the level of probable cause. They can take into account the prior contacts they or other police officers have had with the people with whom they are dealing. They can take into account what police officers know that perhaps ordinary citizens don't know about the way that certain crimes are committed.
One of the most difficult judgments that a law enforcement officer has to make is when they can conduct a search or a stop without having a warrant. There are many situations in which law enforcement is allowed to make a search without a warrant if they observe something that gives them reason to believe that something illegal is going on, and there's no time to get a warrant because the person's in an automobile or out on the street where they can leave the area right away. And so the constraints of the Fourth Amendment are something that always have to be in the back of the officer's mind. But the officers also have to be concerned with effective law enforcement and reducing the danger to the community. The other thing is that the Fourth Amendment is a big source of litigation against police officers. If the police come to your home and search your home and you don't believe they had probable cause, or you believe they went beyond the scope of whatever warrant they might have had, or if they came in without a warrant when they should have had a warrant, that's a very common situation that leads to a lawsuit by the subjects of the search against the police. So the police have to really be able to use their own judgment on whether a warrant is proper or whether a warrant is needed. The Supreme Court has said that the police cannot just say, well, since I had a warrant, you can't sue me. That's not enough. If it's a defective warrant, if the warrant was procured without probable cause, if the officers go beyond the scope of the warrant, the officers themselves might be sued over violations of the Fourth Amendment. And this becomes a very difficult situation because officers often have to make quick judgments on whether they have enough reason to suspect someone, whether there are exigent circumstances justifying them going without a warrant.
So when law enforcement officers violate the tenets of the Fourth Amendment, they are subject to the evidence being excluded per what's called the exclusionary rule. This is far and away the most controversial element of our constitutional law. So the exclusionary rule says that reliable, relevant evidence unlawfully obtained cannot be used in the government's case in chief. This is our law. This is the long-standing law since a case called Mapp v. Ohio. That was a case where a woman named Delria Mapp had illegal pornography in her home. Home was searched illegally, and that was the first time that the court said you cannot use this information because it inures to society's benefit more to exclude this information than to bring it in. It's the only practical way that we can ensure that law-abiding citizens are not subject to these sorts of illegal searches.